Hi, how are you? Good afternoon. Happy Friday, everybody. Thank you for joining us. My name is Hiba Ghalib. I'm an attorney and partner here at Cook Baxter Immigration Partners. I'm happy to discuss with you immigration issues as we do every Friday, and today we're going to be talking about one that keeps coming up, and it's called an I-751. An I-751 petition to remove conditions is an application that one files after they've received a 2-year conditional residency. So what this means is that some people filing for green cards through marriage receive a 2-year green card. Their adjustments of status, once approved, are for 2 years. Normal green cards are 10 years and they're renewable indefinitely. However, a conditional green card is a 2-year period, and the reason for this is because the marriage upon which the adjustment of status took place is less than 2 years old. So one filing through marriage, if the marriage has taken place over 2 years ago and the person's been approved, then you get a permanent 10-year green card. However, if it's a 2-year green card, then it's conditional, meaning you have to do something to remove those conditions, and that's called an I-751 filing. It's a petition to remove conditions. The petition to remove conditions is filed 90 days prior to the expiration of that 2-year conditional green card. It's very important that it's filed timely. If one is not able to file it timely for whatever reason, if they wait till it expires, they have to include an explanation as to why the case was filed late, why the application was filed late, and it should be a pretty good reason. If it is filed timely, however, it doesn't mean that you're going to get your permanent green card right away. It has to be filed with proof of your marriage, and it could take a long time to adjudicate that. Unfortunately, the update on this is that current processing times for I-751s are about 2 years up to 4 years, 48 months. The interesting thing about that is that some people, if they've adjusted through marriage, are eligible to apply for citizenship within 3 years, not the normal 5 years of permanent residency. What that means is you could be eligible to apply for citizenship or naturalization to become a U.S. citizen because you've been a permanent resident for 3 years, even if your conditional residence has expired. So keep in mind, again, the tips are to make sure to file timely, the I-751. Also, keep in mind that there could be a chance that even though that receipt upon filing extends your green card for an additional now 18 months, and it might be 2 years at this point, actually. I'm trying to remember the last time they recently started doing extensions for even longer than that. The normal process used to take about a year, where the extension was valid for a year on the receipt. The original receipt notice, by the way, is proof of that residency extension. So you need that to travel, which again, like I said, you're still a resident. You can continue to maintain, and you must actually continue to maintain your residency if that's something you intend to do as an adjustment, as a permanent resident. But there is a chance, like I said, you will be eligible for citizenships before you get a decision on your I-751. Now, let's talk about a question that one of the common questions I get is, what can I do if my card expired, right, because it's for 2 years, and you file the extension. Your extension expires, which is the receipt you receive extending your green card, which you need to have as proof of your residency, especially if you're traveling, you need the original. What happens then? Am I still a resident? Do I need to do something? And the answer to that is yes, you're still a resident, of course. The only issue is now to be able to continue to renew your driver's license, especially here in Georgia. They're very strict with this. You need to show proof of your residency. How do you prove it aside from this receipt notice that just expired as well? You can go to USCIS and schedule an InfoPass appointment, and you can do that online. It's free. You just go to the website, uscis.gov, and you say schedule an appointment. Just side note, it's really hard to get these appointments lately. Trust me, because I've been trying myself for a few weeks now. The tip is to try at midnight. Some people ask me about that, and I tell them just go wait till 12 a.m., go up, wake up and set your alarm if you sleep earlier than that. Schedule your appointment, and hopefully you find a time that works for your schedule. At that appointment, when you go to the USCIS officer, I would recommend taking the receipt notice, your green card, and asking for a passport, a stamp in your passport. And this stamp is going to extend the validity date of your permanent residency, evidence basically of your status as a permanent resident, and can be used to get a new driver's license. It can be used to show proof of eligibility to work if you need that, and it can be used to travel as well. Again, you're a resident as long as that I-751 is pending. Your status continues to be extended. Now, talking a little bit about what happens if. So a lot of things happen in life, and sometimes the marriage that you based your green card on, that petition, based on the spouse that you had that filed for you, may have not continued. But perhaps at the end of this 2-year period, even though you were in a bona fide relationship, that might be a marriage that just wasn't sustainable and not viable, and maybe in 2 years you're no longer married, or maybe you're separated. This is when, we can talk a little bit now about that, but this is maybe a good time to talk to a lawyer to see what you can do about that petition to remove conditions. If you are no longer married, you can still file and should still file the I-751, and at this point you can file it at any time, so you don't have to wait for 90 days before the termination of your green card, or the expiration, I should say, of your green card. However, if you are filing it with what's called a waiver of the signature, because you no longer are legally married, you need to include proof of that through the termination, either a divorce decree, or if, for example, it was another reason that you are not able to file jointly, you need to show proof of why your spouse wasn't able to sign the form. But you still need evidence of that relationship to be included in that petition. So it's really important to show that this marriage was viable and a bona fide relationship at the onset of the relationship. That is the legal requirement to be able to maintain your status as a permanent resident. Just because you were approved the first time doesn't mean you're going to continue to maintain your status, especially if you're not able to sustain or fulfill your burden to the government to prove that your marriage was a bona fide one and not just for immigration benefits. So I hope that's helpful to you. One thing that you should know is if something were to happen and USCIS, for whatever reason, maybe you were scheduled for an interview and you didn't show up, or maybe you did, but you didn't have sufficient documentation to sustain or to prove that you were actually in a bona fide marriage, then there is a chance that your case could be denied and referred to court. Now, what that means is if you received your green card based on marriage and your I-751 was not approved, jurisdiction then moves, or the file gets moved to court, immigration court, where you'll technically be in removal proceedings at that point. There you will have the opportunity to apply for a new I-751, or actually what is probably better described as a de novo review of your I-751, which is essentially a review of the one that you filed, that you have a right to have that reviewed by an immigration judge who will make the determination regarding the bona fides and whether or not it was a properly filed I-751 that should be approved. So you'll have a second chance at that. Hopefully the judge will understand the law. Sometimes we have USCIS officers that do not really understand what is required, and they improperly refer cases that maybe don't have a lot of evidence in support of their marriage, but they know that they were in a bona fide relationship. Maybe the marriage was a short one. But as long as it wasn't for immigration benefits, then it should get approved. The burden does fall on the government if it was filed jointly. And so, it's still important to make sure you are aware of what your responsibilities are. It's always really helpful, I think, to talk to an immigration attorney. I just got out of a consultation where I spoke with an individual who had filed on his own with his wife. He said 5 years ago now. He thought he was still waiting for a decision. Every time he went in to get a stamp on his passport to extend his permanent residency, no one told him at USCIS that there was anything wrong. It turns out for 5 years he had no idea, but years ago, and he still doesn't know when this happened, they sent his interview notice to the wrong address. He's never moved. He received his receipt notice at his current address, but they sent it to an old address from when he first filed his green card. And he didn't go to the interview because he never got notice. And then he got denied because he didn't go to an interview. He gets referred to court because he got denied. And then he gets a notice to appear to court, which of course he doesn't get either. And then he gets deported because he didn't show up to his court hearing. So he got ordered removed in absentia. Now he's struggling because he can't get a stamp in his passport again, and he just finds out about all this in one day. Can you imagine finding out that you have an order of removal on your record, and in an instant your life will be over? He's still married, he has a child, and he's lived here for years and did everything right. And USCIS, because of an error, an administrative error with his address, basically started a process for him that resulted in him getting ordered removed. Thankfully, he hasn't encountered any kind of ICE officer, any kind of issue, so therefore he hasn't been actually ordered or removed. He hasn't, that removal order we haven't had an opportunity, or I should say the government hasn't had a chance to enforce it. But imagine had he had an issue, for example, where he was encountering immigration, he would have had to deal with a very difficult situation because of the fact that he was ordered removed, even though it was an error. Everything, it's harder sometimes to undo these mistakes after the fact. So long story short, he would have saved himself a lot of trouble had he talked to somebody, an attorney that is experienced in these issues, and probably saved himself a lot of money as well, because his case was pretty straightforward and could have been resolved quickly and easily, especially back in 2012. And 2013, I think, is when he filed it the second time. So yes, I mean, we're here to help you. We're here to answer questions. It's important. Knowledge is power. So please continue to seek it out. I hope this was helpful to you. I will check to see if you have any questions. Of course, if you do and you post them, please continue to post on here any questions you might have, and we will answer your questions either in response to the question on the comments below, or you can always message us on Facebook anytime, and I will see really quickly. And we will answer your questions either. Alrighty guys, so I don't see any questions right now. I hope this was helpful to you. I understand some of you might have questions later after watching this video, and like I said, please feel free to post this on your wall and share it with people that might be going through this situation, and feel free to message us or email us or contact us by the phone number you see below. My name is Hiba, and I hope you have a happy Friday and a great weekend. Thank you for joining us today on Facebook Live at Cook Baxter Immigration.
Mi inspiración principal es realmente muy simple, son mis clientes. Las personas que toman el sueño americano, toman lo poco que tienen cuando vienen y lo convierten en algo increíble. Todos los días mis clientes me inspiran. Cook Baxter Immigration es la práctica de la firma de inmigración más grande de Georgia, sirviendo a todos nuestros clientes en todos los Estados Unidos y en el mundo. Nuestros valores más importantes son simples: integridad, honestidad y valor. Es un honor ser reconocido por el servicio que brindamos a la comunidad a nivel local e internacional. Somos Cook Baxter Immigration, siempre al lado de inmigrante.
En Cook Baxter Immigration estamos haciendo la diferencia con más de 50,000 casos resueltos.
Diferencia que nos posiciona en el cuarto lugar de prestigio a nivel mundial en el área de inmigración.
Nos importa decir la verdad a nuestros clientes acerca de su caso. Si hay una solución a su caso, tenemos la capacidad y la experiencia de arreglar a tu caso. Pon tu caso en las manos de los profesionales. Llámanos hoy por una cita.
Cook
Yo fuimos víctimas de violencia doméstica. Consulté con muchos abogados y todos me dijeron que no tenía un caso. encontré a Cookbuster y ellos obtuvieron para mí la visa U. Luego tuve que viajar a mi país por problemas personales. Lo perdí todo. Necesitaba un milagro para volver. Nuevamente Cookbuster tomaron mi caso y consiguieron para mí la residencia permanente. Gracias, Cookbuster Immigration.